Evidence privileges. Certain individuals have immunity from testifying, and some evidence is privileged, excluded from the court, regardless of its relevancy or reliability. The US legal system holds that the public has a right to every person's evidence, but courts view certain interests and relationships to be of such importance that they protect them from certain efforts to gather evidence. These protections, or exclusions from the general rule of free access to evidence, are known as privileges. Although there are no specific rules written into the Federal Rules of Evidence, federal courts recognize several types of privileges that derive historically from common law. As privileges keep out evidence that might be relevant and probative, the courts construe privileges as narrowly as possible. A privilege can keep evidence out of court when it involves 1. Confidential communication, 2. Within the scope of privileged relationship, 3. Asserted by the holder of the privilege or on behalf of the holder, 4. The privilege is not waived, and 5. The circumstances do not fall into an exception to the privilege. Some privileges are intended to protect certain relationships where open communication is considered important and in the public interests. Confidential communication within the relationships between client and attorney, husband and wife, doctor and patient, priest and penitent are almost universally recognized in some form. In some jurisdictions, other relationships, such as between client and accountant, are also grounds for privilege. Privileges have developed in the United States to protect other interests, such as trade secrets, state secrets, an individual's constitutional right against self-incrimination, and the confidential evidence provided by informers. To encourage clients to communicate freely with their lawyers and to fully disclose any information that may enable their lawyers to provide appropriate legal advice, courts allow clients to refuse to disclose and to prevent any other person from disclosing confidential communication made when seeking legal services. The client has the right to refuse to disclose evidence and can prevent the lawyer or others disclosing confidential communication within the scope of the legal representation. The holder is the client, but the privilege is often asserted by the attorney on behalf of the client. The scope of this privilege is relatively broad. It's not restricted to written or verbal communication. Nods in response to questions and other gestures can be privileged. This privilege applies to clients' communication with their attorneys and with the attorney's office staff. An official client engagement is not necessary. The client-attorney privilege applies to pre-engagement discussions and applies where legal advice is sought or provided pro bono, where no fees or compensation are involved. The client-attorney privilege is available where the advisor is not a licensed attorney, but the client believes he is talking to an attorney. Although the client-attorney privilege is broad, there are a number of exceptions and exclusions. The privilege is waived when it's not timely asserted. Failure to assert promptly can mean the privilege being deemed waived. It cannot be later asserted and the privilege is lost. The privilege is also deemed waived when the client discloses the confidential information to a third party. Communication not treated as confidential by the client will not be protected by the privilege. The communication must be between the client and the lawyer or the lawyer's staff. It does not attach to conversations between the client and a friend, colleague, or another third party in the presence of the lawyer. The presence of a lawyer does not make third-party communication privileged. The communication that is protected is between the client and the attorney. Discussion of matters outside the scope of legal representation is not covered by the privilege. If a partner in a business or a member of a company's board of directors happens to be a lawyer, this does not render the discussions held between these business partners or board members to be privileged. Discussions between two or more people, merely overheard by a lawyer, are not for the purpose of legal representation or advice and are unprotected. When the client is a corporation, the attorney represents the company, and the company is made up of numerous individuals. A large corporation could comprise several thousand employees, and not all discussions with the attorney are privileged. The privilege applies to matters within the scope of the legal representation and to communication with corporate representatives involved in the subject of the legal representation. If the attorney is representing the company in a real estate transaction, but has an unrelated discussion over lunch with an employee in the accounting department regarding money laundering activities, the discussion with the employee could be unprivileged on grounds it's outside the scope of the attorney's legal representation. The accounting employee may also be remote from the real estate transaction, so communication between this employee and the attorney is not privileged. For privilege to be available with a corporate client, the confidential communication must be within the scope of the lawyer's representation and within the scope of the employee's duties. The privilege applies to communication. Non-communication is unprotected. A letter written to the attorney by the client is a communication and privileged. But a copy of a letter written to someone else is not a communication between the client and the attorney. So although it's handed to the attorney by the client, this letter is not privileged. The privilege can be lost under the crime-fraud exception. Communication between a client and attorney to further a crime or fraud is not privileged. This holds true whether the crimes or frauds discussed by the client and attorney actually materialize. A discussion in furtherance of a crime that doesn't take place is not privileged. The privilege cannot be invoked to prevent discussions in furtherance of a crime or fraud being admitted to court. When former partners are in dispute and one offers evidence of communication the partners had with their attorney, the privilege is lost. It's also lost in a dispute between the client and attorney for legal malpractice. The substance of the attorney's representation is at issue in this type of case, and relevant evidence of communication between the client and attorney cannot be excluded from the court on grounds of client-attorney privilege. The client-attorney privilege survives the death of the client and can be asserted by the deceased's client's estates. However, courts have sometimes revoked the privilege after the death of the client in situations where the client's wishes are an issue in a will dispute. The lawyer is allowed to testify as to the communication with the deceased client in order to settle a disputed will. There are actually two forms of husband-wife spousal privilege. The first protects confidential communication between husband and wife, and the second prevents one spouse being forced to testify in the criminal trial of the other spouse. The first privilege protects the privacy of communication between legally married spouses. The privilege allows the husband or wife to refuse to testify about a conversation or a letter that they had privately exchanged as marital partners. The privilege is held by the speaker, but can be asserted by the listener. The spousal communication privilege continues after divorce. Confidential communication between the spouses exchanged during the term of the marriage is protected, even after the partners have divorced. The second, spousal testimony privilege, allows a witness to refuse to testify against his or her spouse in a criminal case. The husband can refuse to testify against his wife, and the wife can refuse to testify against her husband. It applies in civil, not criminal cases. The privilege is traditionally held by the accused spouse, but in many jurisdictions it's now held by the witness spouse. Unlike the spousal communications privilege, the spousal testimony privilege terminates at divorce. Following divorce, an ex-husband can be forced to testify against his ex-wife, and an ex-wife can be forced to testify against her ex-husband. So following divorce, communications between the husband and wife are privileged, but other forms of testimonial evidence are not. The wife can be forced to testify about what the ex-husband did and what he said to others, but not what he said to her in private. Like other privileges, the spousal privilege is waived when not timely asserted. Communications during marriage are protected, but not communications before the actual wedding. The privilege attaches to the legal wedding, not before. At the legal wedding, not before. In many jurisdictions today, when one spouse wishes to testify against the other in a criminal trial, she will not be prevented on grounds of spousal privilege. The testimonial privilege is also set aside in cases of spousal abuse and child abuse, where testimony of one spouse against the other is often essential. A level of trust must exist between a doctor and a patient to facilitate the patient's proper treatment. If the patient were fearful of telling the truth to the doctor because he or she believed the physician would report such behavior to the authorities, the treatment process could be rendered far more difficult, or the physician could make an incorrect diagnosis. This privilege protects medical records as well as confidential communication between patient and doctor or psychotherapist. The doctor must usually be a licensed physician, psychiatrist, or hold a PhD in some form of psychotherapy. The privilege is held by the patient, but is often asserted by the doctor on the patient's behalf. The doctor cannot be forced to reveal the information except for medical records. There are some exceptions or exclusions. The privilege is deemed waived by failure to assert in a timely fashion, or through disclosure of the information by the patient. Like other forms of privilege, the information must be confidential to qualify for protection. As soon as the information is voluntarily disclosed, confidentiality and the privilege are lost. A large exception to the rule applies in criminal cases. In many jurisdictions, the doctor-patient privilege does not apply in criminal cases at all. Another exception applies where the patient places his or her medical condition in issue in the case. For example, details of the injury in a personal injury case would not be excluded on grounds of doctor-patient privilege. In a famous case in California in the 1970s, a therapist was successfully sued for failing to warn a third person of his patient's desire to harm her. Now the therapist can be held liable for failing to warn of a specific threat against a specific named person. Secrecy is considered the essence of penance in the Catholic Church. The sinner will not confess, nor will the priest receive her confession if the veil of secrecy is removed. So the confession to the priest is confidential information. Confessions made in the confession box are not revealed in court. This privilege allows the priest to reveal the confidences of the penitent. It is held by the priest, but can be held by the penitent in some jurisdictions. The privilege is not restricted to the Catholic religion, but applies to other religions as well as spiritual and relationship advisors. The exceptions are few, but in the Catholic religion, the privilege can be waived by the Pope.